A mother holding her baby was run over in a parking lot. Samantha Skinner made the ultimate sacrifice, shielding her child with her own body. In an instant, Samantha was killed. Now, a 1-year-old is left without her mom, and a man sits behind bars accused of being under the influence. I'm Kennedi Walker, and this is Law and Crime. Samantha Skinner will never get to see her daughter laugh again, graduate, or walk down the aisle. Instead, the final memory they'll ever share is Samantha giving her daughter the gift of life one more time. Samantha, known to her loved ones as Sam, was struck and killed by a suspected impaired driver in a Michigan parking lot. In her arms was her 1-year-old daughter. And in those final moments, as she was hit by a Ford Explorer, Sam used her own body to shield her baby. According to Michigan State Police, a 72-year-old man pulled out of a parking spot next to Sam and hit her. Sam was there for a routine custody exchange for her stepson. It was a handoff that should have taken just a few minutes. Instead, it turned into tragedy. State police say they interviewed the driver of the commercial-grade Ford pickup truck and during the interview developed suspicion of narcotics impairment. The man, who has not been publicly identified, was arrested, and troopers obtained a warrant for a blood draw before releasing him. In a statement, Michigan State Police said, while many drivers are aware of the impacts of alcohol while driving, we continue to remind drivers the same is true for drug impairment. It does not matter if they are prescribed drugs, marijuana, or over-the-counter, they all impact your ability to drive. On the scene, cops administered CPR until paramedics arrived and pronounced Sam dead. In a split second, Sam's life was gone, and the lives of everyone who loved her were changed forever. Her toddler daughter was rushed to the hospital with non-life-threatening injuries. A GoFundMe has been set up to help Sam's family as they now face life without her. Loved ones describe Sam as kind, selfless, and a great mother, which was proven because even in her final breath, Sam did what came naturally, protect her baby, no matter the cost. And here to break down this story with me is criminal defense attorney Jeremy Eldridge. Jeremy, thank you so much for coming on today.
Thank you for having me.
So if narcotics are suspected, what kinds of tests or substances are investigators usually targeting in a case like this one?
After an accident, in most states, the police have the ability to do one of two things. Either A, detain the suspect, meaning the driver of the vehicle that caused the collision. And if they believe it's an emergency, they can take that individual to the hospital and they can do a blood kit, which is literally taking blood from that individual. A lot of states, just to protect themselves, have laws in place where the police can actually go get a search and seizure warrant and then once again take a blood test. So the only question is how the police want to handle taking that blood test, but undeniably, it's going to get done.
How quickly do those toxicology results need to come back in order to support serious charges like second-degree homicide?
That's a really good question. And unfortunately, in these cases, one of the reasons that we don't often see suspects charged quickly, sometimes cases like this can take 6 months to a year to get charged. And the public has a difficult time understanding it, but the rationale is simple. You have to do an investigation in these cases before charging. So for instance, you may be waiting upwards of a month to 60 days for that toxicology to come back. You might be waiting for the accident investigation unit, which is a specialized unit within each police department, of which there are only a couple officers that are trained and certified as experts in this field, to come out to the scene, to do measurements, and to produce a very, very lengthy report that involves a lot of math and calculations about how the actual collision occurred. And so until you get that stuff back, prosecutors sometimes are hesitant to charge. Now, sometimes they'll charge even more quickly, day of charging, and then work the rest out as the case goes on. But in a lot of these cases, there's actually a fair amount of time that exists for the investigation to ensue, to finish, and then for charges to be brought.
Does the type of drug, let's say prescription opioids versus illegal substances, change the legal exposure for the driver?
It could actually make the case stronger against the driver, which may sound counterintuitive, and the reason is this. On most of the narcotic medication, most of the pain medication that we're talking about, even if you're lawfully prescribed it, right on the bottle, it says, please do not operate heavy machinery, please do not drive, could cause sleepiness, please cause impairment. There are very few controlled dangerous substances that are prescribed when it comes to pain medication or anti-anxiety medication, which is another class of drugs that could be considered in a case like this, or those kind of drugs taken in combination with one another, where the pill bottles don't have those warnings on them, or when the pharmacist gives them to you, you aren't warned. And so if it was marijuana, for instance, that would actually be a whole lot different situation, because science does not provide us with a test that can say at this time you were high on marijuana unless the person admits to it. Because you can do follicle testing, meaning hair, you can do blood testing, you can do urine testing, but all that says is that there's the presence of marijuana in your system, the metabolites, but it doesn't actually say when you were using marijuana, especially if the driver doesn't make an admission to using marijuana before the incident. Unlike other narcotic medication or alcohol, when that presence in your system does allow us to draw some inferences about when and how you took it.
So we're, of course, waiting on those results. We don't know exactly what is in the suspect's system. But are you saying that hypothetically, a person that had smoked marijuana earlier in the day, let's say they're driving, they get into a car wreck, if they don't admit that in that moment, yes, I just smoked, 30 minutes ago, they have the potential of maybe getting off?
Yes, at least as far as a charge that would involve a controlled dangerous substance. If there still were reckless driving or other factors that contributed to the death that they could prove outside of the marijuana's usage, yes. But marijuana in and of itself without an admission is almost impossible to prove in court insofar as using any sort of biological or scientific testing, because the science just isn't there yet.
So if he did take any type of prescribed medication, which again, we don't know, how was that proven in court? Just through that toxicology report?
Well, the first thing you would want to do is be able to prove as the prosecutor that the individual had access to the medication. So, once again, the reason it might be easier for them is, unlike buying Percocets on the street, for instance, or fentanyl on the street, here, if you know it's lawfully prescribed by a physician, you may have just taken it in a contrary nature to its intended use or intended timing of use or manner of use. Then what you're talking about is you can send a subpoena to the doctor or subpoena the individual's medical records, and then you have proof that they prescribed the drug in the first place. The second thing ends up being a lot of people in these cases, candidly, they end up making admissions about the driving. I see it more often not in these cases than any other type of case, because a lot of the people in these situations have never been in trouble before. Also, if they're injured during the collision and they're taken to the hospital, some of the statements that they may be asked about, for instance, were you in a collision? What happened to you? Most states have what's called an exception, a hearsay exception, meaning your statements are admissible against you in court if those statements were germane to medical treatment, meaning if the providers were asking you questions that were necessary for your medical treatment, but that also maybe inculpated you or showed your involvement in a crime, those statements may be admissible against you in court. So a lot of people don't know that. They're answering these medical questions. These exceptions in the law exist for a reason, and the reason is to use them against an individual in court.
Wow, I'm surprised that doesn't count under some type of HIPAA law, especially if you're talking to your doctor.
If you come back at a later time and you're asking questions that have nothing to do with treatment, for instance, if the police come and start asking you about what happened, that is obviously not covered, because if you're in their custody and they're asking you questions that are functional equivalent of interrogation, then you're in custody, and that triggers what are called Miranda warnings, the old Law and Order. You have the right to an attorney, and if you don't have money, then we'll appoint someone for you, those sort of Miranda warnings. But if we're talking about a healthcare provider and they're trying to assess the damage to your body, they're trying to understand the nature of what happened, a doctor, a nurse, a PA, and they ask these questions, those questions would be considered germane to medical treatment. And oftentimes as lawyers, we get into arguments, having been a prosecutor, defense attorney, argue these on both sides. Sometimes we are arguing both sides of that in court. And then a judge has to ferret out which of these statements, some or all or none, would be admissible against that individual during the prosecution in front of a judge or a jury.
With the driver now under arrest, what are the most serious charges he could realistically face under Michigan law?
I think what you commonly see, although people throw around words like murder, in reality, what he's probably looking at most is a combination of reckless driving, which carries a maximum of 93 days in jail, combined with involuntary manslaughter, which carries a maximum penalty of 15 years in jail.
Any idea on where he could potentially land in that? Of course, we don't know, but if you had to guess.
On involuntary manslaughter, and I think this is what's troubling for people to understand, when we look at calculating or estimating what kind of sentence a potential criminal defendant gets, one of the things we usually look to what are called sentencing guidelines, which is a book that every state uses, including in the federal system. And the book looks at what's your offender history. Have you been in trouble before? And then it also looks at the nature of this offense or how serious this offense is. Both of those give scores or numbers. And then, no different than a bell curve, there's a chart, and we can kind of see that the more serious your criminal history, the more serious the offense, the numbers for jail time get bigger. And that applies to most cases, except cases like these. I have found that judges tend to go over the guidelines on these. In most states, the sentencing guidelines on these seem to feel, and I feel is not a word that lawyers use often, but feel artificially low. And for that reason, the judges tend to sentence over guidelines or near the top of the guidelines. So, for instance, an individual that may not have a record, their sentencing guidelines could be, let's say, between 2 and 8 years, but judges can go above guidelines if they feel as though the person essentially deserves a higher sentence for their role in the offense or the destruction that they caused, or if we find out that this individual had an extraordinarily high test of breath, meaning above a 0.15 or above a 0.20. So there are certainly aggravating circumstances if he was abusing pain medication, if he didn't cooperate with law enforcement and then lied to them, obstructing the investigation. These are things that could be seen as aggravating circumstances and potentially cause a higher sentence, even if he were to plead guilty.
Could prosecutors ever add felony child endangerment just based on the fact that the victim was holding her baby at the time?
It's possible, but not probable. I think that if the prosecutor wants to lay it on thick, whether it's for political reasons or whether it's to stack charges so that to really force the defendant in a particular direction, they certainly could do that. But when you're looking at going to trial, if I'm a defense attorney, what is the charge that my client is going to have the most serious concern with? It's going to be involuntary manslaughter, because operating while impaired or intoxicated in the state of Michigan may not be difficult to prove if he admitted to using prescription drugs. Obviously, that news is already out there in the ether. At least we all suspect that is the reason. If there's alcohol involved. So once you get to OWI in the state of Michigan, to get beyond that to the charge of involuntary manslaughter is probably not a stretch. And those are going to be the two charges that he's going to be the most worried about.
Does the fact that the suspect is 72 years old help or hurt him in the eyes of the jury?
Assuming that he has no criminal record, it's going to help him. Not only is that going to help him, but the cause for being on the medication is going to help him. So, for instance, let's say that he was involved in receiving this medication for palliative care reasons, meaning that he was in a lot of pain and this was pain management medication because he's suffering. He would say dying of cancer. And I'm making that up. Obviously, we don't know that to be true. But if there were more sympathetic reasons for the use of the medication in the first place, there was no criminal record, that would certainly work in the defendant's favor. And I'll also tell you, having represented people in more than 15 or 20 of these cases within the last 5 years, just in the state of Maryland, that oftentimes the people that get in trouble for these cases are people that haven't been in trouble before. A lot of people that have been productive members of society, a lot of people who didn't want to hurt anybody when they got in the car and then ended up causing a horrific car accident and somebody's death or somebody being paralyzed. And so a lot of people want to take responsibility for it. They just hope that they don't receive a barbaric sentence, something well above the sentencing guidelines. Everybody, of course, wants to stay out of jail, even if they feel bad for what they did.
In this case, do you think an alternative like home confinement is even on the table? Or with this case just being so sad, a young mother losing her life in this way, there's no way that would happen?
Given this individual's age, it would be interesting to know some things that we don't know now. For instance, that individual's healthcare situation. If, for instance, the pain medication that we suspect the driver was utilizing was for a serious medical illness, that could factor into a judge's decision down the line to impose incarceration or a prosecutor's willingness to recommend it. If the person was, for instance, dying of cancer, like I brought up before, then maybe home detention or some confinement within the residence and allowance to go to medical appointments only could certainly be an option here. But simply because the individual is 70, if that person was simply abusing pain medication at 70, 70-year-olds these days are a whole lot younger than 70-year-olds were a couple of decades ago. So if we have somebody that's just abusing pain medication without a good reason and they've never been in trouble, then honestly, jail time is more than a probability. It's almost a definite probability.
If the defense argues that the crash was accidental, what's the legal bar for proving criminal recklessness instead?
Well, let's back up a little bit. The problem is going to be it doesn't require intent to have hit the child. So if you're operating while impaired and then you cause the death of a child, that's involuntary manslaughter. You don't need the intentional act. You need the intentional act of driving. You don't need the intentional act of harming anybody. And so driving while impaired, causing the death of an individual is going to satisfy the elements of involuntary manslaughter. Now, look, to your point, if they can't prove that he's impaired, and that's a rumor that made its way into the public sphere but isn't well founded, and it's not operating while impaired, then they're not going to be able to prove involuntary manslaughter, and they may only be able to get to reckless driving. But this is going to be horrible to say, but we do call them car accidents for a reason. And in the end, if there's no impairment and we just have an older person who didn't see somebody in their mirrors, then it may just be a car accident, and we may be dealing with a civil case and negligence.
And I'm glad you brought that up about the civil case, because I was just about to ask how they might go down that road. Before I do, I mean, I know you are a criminal defense attorney. I'm very interested to know how you would argue this case and then flip it, not just as the criminal defense, but if you were prosecuting it, how would you go about it as well?
So, as a prosecutor, the first stage of these cases is what I would call the hunter-gatherer phase, which is making sure that you have the universe of evidence that needs to be collected, and it's been collected properly, and it's being tested in accordance with the standards of that state. So, for instance, if we know there's toxicology, was the blood pulled correctly? Did we get a search warrant for it, or do we meet the exigency standards? Next thing, have we ordered medical records? Have those subpoenas gone out? Are they being complied with by the healthcare providers like the hospital? Next thing, are we collecting the body-worn camera footage? Do we have it all? Have all the police officers turned it in? Have the witnesses that were at the scene been interviewed? Do we need to re-interview them? Do we have all of their information? Have subpoenas gone out for them for court? As a prosecutor, this stage right now is integral to being able to have a prosecutable case down the line. Because if you don't have anything wrapped up now, if you're not buying the Christmas presents, there's nothing going to be wrapped the night before. So right now, it's making sure that you have everything prepared, all of the ingredients to cook, right? After that, it's then going to be, what are the holes in our case? Are we able to put this individual behind the wheel? Are we able to show that they're impaired? What do the medical records show? And then, if you believe you have a strong case, you make a plea offer in accordance with that, something like involuntary manslaughter. If there are some holes in your case, then you need to start negotiating downwards, right? If you're a defense attorney, you're going to be making sure, as this discovery, meaning as a copy of the evidence is sent to you in compliance with the rules of the state of Michigan, which is going to be 30, 60, 90 days out from now, you're going to start seeing, what do I have? What am I missing, right? Are there any issues with the way that they collected the blood? If there are, I'm going to file a motion to suppress, arguing that the prosecutor should not be able to introduce this evidence because it was collected in violation of my client's Fourth Amendment rights to be free of unreasonable searches and seizures by the government. That's why they often urge police. And a huge issue in this case could be, did the police pull the blood by exigency, or did they get a court order? Most police officers at this point know that they should get a court order. Some of the state statutes in serious bodily injury cases allow it without a court order. But we're going to be looking for compliance and non-compliance issues by the police department. When witnesses were interviewed, were they essentially, I don't say told what to say, but were they led, or were their statements free and voluntary? Do they match what they wrote down? A lot of the time in these car accidents, you have witnesses writing down brief statements and then interviewed later. Are those statements consistent with one another? Or for instance, once they found out that somebody died, did they exaggerate? That's the kind of stuff that the defense attorneys are going to be looking for. At the same time, we're going to be preparing mitigation. Our clients are going to be in treatment. If he's 70 years old, I'm probably going to have all of his medical records ordered. I'm going to find out why he was on the pain medication. I might retain an expert in forensic psychiatry, for instance, to figure out if he had a substance abuse issue, where that came from, what else was going on in his life, getting a letter, getting him assessed. Are there mental health issues at play? Are there physical issues at play that I can go to his other care providers and figure out why and then document them, ultimately to write a sentencing memorandum to the court to convince the court to impose a lower sentence, or to share with the prosecutor, if need be, to negotiate a better plea agreement. And so we kind of go down both paths at the same time as a criminal defense attorney, which is, we're going to prepare for trial and we're going to prepare to plea. It's just not knowing which track you end up on, but you have to do both at the same time. Prosecutors have the luxury of only investigating a case and preparing it for trial and making a plea offer. They're not preparing to plea. They're preparing to make you an offer and decide whether my client will accept it.
Well, beyond the criminal trial, what What do you think this case might spark? Could Sam's family pursue a civil wrongful death suit while the criminal case is still pending?
They should and they will. I mean, I think it's fairly obvious. These tracks will run somewhat parallel. They could intersect at a time if the defendant pleads guilty in the future. That conviction could be used as evidence in the civil case, but probably isn't necessary. There doesn't seem to be much of a debate as to who's driving the motor vehicle and who caused the death. I think the question at this point is more whether there's criminal liability, not civil liability. Criminal liability has that beyond a reasonable doubt standard as to whether you can prove operating while impaired or whether you can prove involuntary manslaughter. Whereas in civil, you just have to prove that the person was negligent, meaning they had a duty to drive safely and they breached that by harming both the mother of the child, by killing the mother of the child, and obviously harming the 1-year-old. And so the question at that point becomes how much money, because that's what civil cases are about. Right? They're not about accountability. That's what the criminal case is for. This is about money. And so it'll depend what the insurance limits are, who has insurance, and then dealing with both the insurance of the victim's family and the insurance of the operator's family to see whether there's what's called stacking, which is whether the policies will be stacking on top of another or whether you simply have the policy limits associated with the operator's policy. And they will probably simply pay out whatever the maximum is. In a death case, most people, for instance, driving have 100,000 or 300,000 or 300,000 to 500,000. When somebody dies, you're going to hit those numbers pretty easily, especially when you have the death of one individual and then a 1-year-old who is severely injured. You're going to hit those limits pretty easily between medical bills and then just the idea that somebody died. So the insurance company, the driver, is probably going to pay out. What you have to be hoping for that you're not asking is that there's a policy of that magnitude. Most states, the minimum policies are 15-30 or 30-50, and that's really not a lot of money when the mom dies and she's trying to feed the family, working mom, losing all of that income. If you're talking about getting $15,000 or $30,000, that's not going to put the family in any position that's going to benefit them or the children in the future.
Well, this is a story that we will be following closely. Jeremy, thank you so much for coming on today.
My pleasure.
As of this recording, the GoFundMe for Sam's family has raised more than $100,000. Authorities say troopers will complete their investigation and send their findings to prosecutors who will determine what criminal charges are warranted. For Law and Crime, I'm Kennedi Walker.